There is an automatic right of a child and a duty on a parent to provide for their children, either during their lifetime or after, in accordance with their means. If you don't have a will and you have assets, one of your relatives will more than likely step up and act as an administrator to your estate and make application to the probate registry for letters of administration with no will, and your estate will be distributed in accordance with your family tree. We will meet with you. We will take detailed instructions from you. We will advise you according to your wishes what you want your will to provide. We will then draft your will over the coming days, and when it's agreed and the format is agreed in, you'll come back to the office and we'll have 2 witnesses available to witness your will. You'll sign it in the presence of the 2 witnesses. We'll seal it and we'll enter it into the wills register, and you can either take the original away with you, or generally most people will just take a copy to leave with their papers at home, and we'll keep the original in the safe in the office. There are thresholds that your beneficiaries fall into in categories, and some categories have more taxable allowances than others, such as a child of a mother-father has a maximum tax threshold. Then it comes down the line to brothers and sisters, aunts and uncles, nieces, nephews, etc. So there's a few thresholds where exemptions apply, and which is where you fit into those thresholds, or where the beneficiary fits into those thresholds, is what's important. It's important to have a solicitor when you're doing up your will, because if the testator leaves you something and you witness it, you can't benefit from that gift. So there are very specific rules insofar as the testator needs to be in the presence of 2 witnesses, and all 3 have to be in a room at the same time, all sign at the same time. So there are certain procedural requirements that are very specific to making a will.